So my name is Stephen Shrybman. I'm a partner at Sack Goldblatt Mitchell. I practice constitutional and international trade and public interest law. And we've prepared an opinion, as Barry's indicated, looking at the constitutional implications of Bill 32. And I'll take you through that in a moment. But before I get there, I just want to introduce the comments by pointing to a couple of the key features of the TILMA agreement itself. You need to understand what that agreement is about in order to understand its constitutional implications. And there are really two that are particularly noteworthy for the purposes of our assessment of the bill, which would implement the agreement. The first is the general prohibition set out in TILMA in Article 4 on government measures. And we know that under the agreement, governments mean municipalities, provincial governments, and boards and agencies and other public bodies in the province. There's a general prohibition on measures, in other words, actions or policies or regulations implemented by those governments or public bodies that interfere with or diminish in any way the rights of investors, labor mobility, or interprovincial trade. In our view, that's a broad and sweeping prohibition on virtually, certainly by some interpretations, everything that governments and public bodies do. Simply by acting, governments and public bodies intervene in the marketplace. They necessarily affect investment and labor mobility and trade, particularly in an integrated and Canadian and international economy. The sweep of the regime and the extent to which it applies to the actions of governments and public bodies is, of course, disputed by the province. The minister tells us it's only intended to catch discriminatory government measures, in other words, actions taken by governments that discriminate against investors or individuals or goods that would come into Alberta come into British Columbia from Alberta. But that's not what the agreement says. There are provisions in the agreement that speak about discriminatory measures. This broad prohibition set out in Article 4 doesn't. So in our view, it's very sweeping in its application, and ultimately what it means and how it applies won't be determined by Mr. Campbell or Mr. Hanson or even the legislature or his cabinet, but by private arbitrators, and that's the other feature of TILMA that I just want to briefly mention, and that is the right it creates to the benefit of individuals and companies and investors in Alberta, and of course vice versa, to claim monetary compensation against the people of British Columbia, where their elected officials or public bodies or agencies do what they are empowered lawfully to do, and what they may do entirely within the framework of their statutory mandates and within the Constitution. It's a way of punishing the people of British Columbia for the lawful actions taken by the people that represent them or that are appointed by the public bodies that are elected by them. Those are the two features that you need to keep in mind when you consider the implications of Bill 32. So to Bill 32 then, the bill implements TILMA. It sets out 16 amendments to provincial, it sets out various amendments to 16 provincial statutes. The most important of those amendments are amendments to and let me just get the name of the statute correct, the Enforcement of Canadian Judgments and Decrees Act. And in our view, that's the most important amendment because it provides for the enforcement of an award made by a TILMA tribunal. This is a private arbitral tribunal that's convened when an investor, for example, from the province of Alberta have some complaint about some public policy law or regulation that has been taken or implemented or established by a BC public body. an award by that tribunal is enforceable pursuant to this amendment to the Enforcement of Canadian Judgments and Decrees Act as if it was a judgment of a Canadian Superior Court. So the tribunals are authorized to award up to $5 million in monetary compensation arising from the lawful actions of public bodies in British Columbia. And you can take that award and file it with the Superior Court in BC, and it will be enforced by the sheriff, or however else you might enforce a judgment of a Canadian court under BC law. There are other amendments to provincial laws, particularly those that empower the cabinet to pass regulations that would override the statutory provisions of the statutes, the actual provisions of the statute giving cabinet the authority to make regulations. I'll come to those in a minute. The courts have described those as Henry VIII clauses because they arrogate power from legislatures to the executive of the government, and that was something that the king was fond of trying to do or get away with. And I'll come to those amendments in a minute. But let me take you through the four essential conclusions of our opinion. I'll do this quickly, and I'll try to do it in the vernacular rather than offer kind of the legal language and citations that you'll find in the decision if you have a chance to review it. I think in the simplest terms, the way to understand what the government's doing with this bill is that it's seeking to arrogate power. This political administration is seeking to arrogate power to itself from the legislature, not just the sitting legislature, but future legislatures, and not just legislatures present and future, but also from the courts, and in another respect, from the federal government. Yet the institutional arrangements between the legislature, the executive of a government, future governments and a sitting one, and the federal and provincial governments are relationships that are set out in the Constitution. By ignoring the boundaries that are defined by the Constitution, in our view, this bill challenges the very most fundamental norms of our constitutional arrangements in four respects. The first is that the bill amends two or three provincial statutes, the Cooperative Association Act, the Business Corporations Act, and I think the Financial Institutions Act is the third one. And those amendments give the cabinet the right to pass regulations exempting companies or cooperative associations from Alberta from the requirements of British Columbia law. The amendments also give cabinet the authority to override the provisions of the statute itself, and the amendments say where there's a conflict between the regulation and the statute, the regulation will prevail. Courts take a dim view of allowing the political administration of a government to, in a sense, assume what should be the proper prerogatives of the legislature to pass whatever laws it chooses from time to time to pass. And I wanted to just read you an excerpt from the way in which the courts have characterized this particular problem of overreaching executive authority. This is what the Supreme Court of Ontario had to say in a case decided in 1997, which is in our opinion, referring to a similar effort by that political executive. This breathtaking power to amend by regulation the very statute which authorizes the regulation is known to legal historians as a King Henry VIII clause, because that monarch gave himself power to legislate by proclamation, a power associated since with the 16th century executive autocracy. It is unconstitutional for an executive to attempt to arrogate from the legislature its prerogative to determine and pass laws of its choosing. So that's the first concern, constitutional concern we raise with respect to Bill 32. The second is that not only does the executive, through this instrument in the bill, attempt to assume powers that properly belong to the legislature, the sitting legislature, but it purports to do the same thing with respect to future legislatures. By imposing on those legislatures, the government, future government, constraints arising under TILMA, and most notably the one that it can be punished. Those future governments can be punished for doing things that are, while entirely lawful and constitutional, nevertheless offend TILMA rules, as those arbitral tribunals may at some time in the future decide the rules to be. In fact, we're told by Minister Hanson that the whole purpose of the bill is to constrain the exercise of legislative authority. That, again, is something that the courts in Canada have taken a very dim view of, for the same reasons that they have resisted efforts by executives to empower themselves to pass regulations overriding the will of provincial parliaments or legislatures. The third constitutional problem we've identified with TILMA has to do with the attempt of the agreement and the bill to arrogate power from the courts by delegating the judicial authority that under our Constitution is invested in Canadian courts to resolve disputes between individuals and companies and the states concerning public policy and law. If you have a problem in this country, you're a company trying to sell a particular product, perhaps a hazardous product, and the government is doing something to prevent you from doing that, there are two places you can take your complaint. If it's a political problem, you can go to the politicians. If it's a legal problem, you can go to court. You can't take a complaint about something that governments have lawfully done to an independent arbitral tribunal operating largely outside of the parameters of Canadian law and constitutional law. Yet that's precisely what TILMA authorizes. So instead of going to a BC court because you have a complaint about an environmental regulation in the province, now you can take your complaint to an arbitral tribunal and end up with a monetary award if you're lucky, because the government refuses to accede to your complaint, even though a tribunal has found the government to be out of line with its obligations under TILMA. The constitutional authority of Canadian courts is protected by Section 96 of the Constitution, and in our view, TILMA offends, and the bill that would implement TILMA offends that constitutional safeguard. The last one has to do with, you might describe this as an attempt by the province to assume federal authority, because under our Constitution, trade and commerce is a federal head of constitutional jurisdiction that doesn't belong to the province. And the courts have struck down, not infrequently, provincial measures that ignore those constitutional limits, which raises an important question about what TILMA is in the first place, because if it's really about trade, investment, and labor mobility, anything the province did that actually interfered with trade, investment, and labor mobility would offend trade and commerce powers and could be challenged on that ground. In our view, most of the measures that would be constrained by TILMA have nothing at all to do with interprovincial trade or investment or labor mobility. Even if they indirectly have some impact on those matters, they are by pith and substance matters within provincial jurisdiction. Nevertheless, under TILMA, a tribunal may award or authorize retaliatory trade sanction. The purpose of that sanction would be to interfere with interprovincial trade and commerce, and for that reason would offend the limits of provincial constitutional authority with respect to such matters. So those are the four respects in which, in our view, this regime and Bill 32, which would implement it, offend the very bedrock principles of the rule of law, of democratic authority invested in provincial legislatures that upon which Canadian constitutional arrangements are founded. So perhaps I've given you too much information, but there's my summary.
Any questions for Shrybman or O'Neill?
I have two. First of all, to either of you, to your knowledge, is there any precedent of a province initiating legislation similar to this TILMA legislation?
No, the regime is entirely, I mean, the only precedent for the TILMA agreement itself is the Agreement on Internal Trade. But the Agreement on Internal Trade didn't include legally binding enforcement mechanisms, and there's no provincial legislation implementing it that we're aware of. So the notion of two provinces negotiating an agreement that creates a legally binding mechanism to constrain the activities of its own government to do things that are lawful and constitutional is entirely unprecedented.
My second question, and I'm sure you're probably curious about this yourselves, if the TILMA legislation stands and independent arbitrations are set up, who would monitor the conflict of interest if, of the arbiters in situations like that, if they were to arise?
Well, I think the agreement does stipulate that people nominated by the province are to be free of conflict of interest, but I don't think there's any accountability mechanism there. And perhaps more problematic is the fact that there are really no qualifications that are set out for who would be appointed to these tribunals. Even if you thought empowering an ad hoc arbitral tribunal to pass judgment on the lawful actions of a school board in British Columbia made any sense, we don't. So the problems we have with the mechanism go well beyond the fact that it's relatively untransparent and unaccountable, and the people that sit on these tribunals may have conflicts of interest for that matter, or just simply be unqualified to do the adjudicative work that's been assigned to them. But the nature of the task is corrupting and unconstitutional in our view.
Hypothetically, could you or your firm correct this legislation, the defaults, so that it would achieve some public purpose, or is the whole thing need to be burned?
Yeah, I don't think there's anything that's salvageable in the legislation. I think what might be salvageable is the notion of trying to deal with real impediments to labor mobility. I don't really think there are. I mean, we've certainly done our best to try to determine whether or not there are actually any trade impediments or investment impediments that exist in British Columbia and Alberta. We can't find those. But there are rules and regulations that apply to the licensing of doctors and lawyers and nurses and carpenters and machinists and machine operators. And they can vary from province to province, sometimes for good reason. There are differences that perhaps aren't warranted. And there's been a lot of activity, I think, over the last 10 or 15 years to try to resolve duplicitous licensing requirements. There are various programs in place. I think progress has been made, significant progress has been made on that front. Perhaps more progress could be made, but you wouldn't need an agreement like this to get there. Those are political problems, and it's perfectly appropriate for ministers and premiers to sit down one with the other and try to sort them out. But this whole notion that there are significant trade barriers as between Canadian provinces, I think, is one that would have most Canadians properly scratching their heads to understand.
It's difficult to actually know the purpose of the legislation in the first place, as Stephen has said. That in simple terms, if you asked a worker who was working in Fort McMurray how much mobility problems he had with labor when he started to work there, or vice versa in Vancouver, or whether or not unloading one hay truck between Alberta and BC constitute putting a trade agreement together, I'm not sure whether or not the purpose of this legislation is very clear, and certainly the questions that we asked, more likely, I would think, in my view, that it's a push to kind of lower the common denominator around qualifications, around workers' rights, benefits, workers' compensation, and those kinds of things. If I was to guess, that's what it's more relevant, and that's what it's all about in my view. Because there really is no labor mobility problems that we've seen or encountered, and certainly the number of complaints that have come forward, both from British Columbia, Alberta, and in fact the nation, would tell us that it's not significant enough a problem to actually put together something that would be as risky as a trade agreement. You know, I think if you look at some of the international stuff, there is some relevance. This, I guess, in past have called upon TILMA to be son of NAFTA. There certainly are some similarities in this, but I don't think the purpose for TILMA is very clear to anybody, and regardless of the number of questions we ask, we simply aren't getting the answers, or people don't know the answers yet.
So what are you going to do with the legal opinions, sir?
Well, I'm hoping, I guess if we had it our way, that it would cause the government to actually slow down at the very minimum and start to think about whether or not the opinion that we have, and more, I think that more important, the concerns that some major organizations, not just unions, I mean the UBCM, the FCM, all kinds of organizations have come out and said, we can't, in particular, I think the whole local government thing for me is important. If in fact our economy as it is right now in northern British Columbia in particular, where local governments want to get outside the box and support local business and do some things with them, if we agree with nothing, we do agree that if the TILMA's passed, that's not possible for local governments to do that. So those kinds of things, I suspect that's why the FCM or the UBCM actually has some significant problems with it. So the answer to the question is I would hope they slow down. I'm not overly confident they will. We're facing 9 or 10 bills now that are going to face closure by the 29th. This is one of them, in my view, but I don't think that there's any intention for anybody to do anything. Whatever we have to do, I think the onus is on us to make it happen. And other organizations will do the same. The unfortunate part of this is any action that we may take around this bill or others certainly won't be in place before the next provincial election. And that, to me, is obscene.
So you're stopping short of saying that you intend to challenge this legislation in the courts.
No, I'm not stopping short. We don't go out and get legal opinion because we had nothing to do that day. We get a legal opinion because we want to know what our position is. And I think that our members, from my organization in particular, expect us to do with something with that if we're not satisfied that the government is at all paying attention. It wouldn't, we haven't developed that strategy fully yet. We just got the opinion back and we're talking about those things, but certainly any move that we make from here will be significant. But we're, I guess, not optimistic, but hopeful that the government will take some of these things under consideration and perhaps move this off the docket. Maybe there needs to be more time to think about it, to talk about it, and perhaps that needs to happen after the next provincial election. I'm not sure what the consequence, but we don't put lawsuits in place if in fact government's actually going to make a move to change something.
Is there parallel news conference happening today in Edmonton? I mean, this thing is illegal in BC, vis-a-vis an agreement with Alberta. Is it reciprocated on the other side?
Well, I'm not sure what's going on in the rest of the country. The only thing I know is what's going on in Prince George this morning and what's going on here right now, because I've been in both places. But there are other agreements that are being talked about, and Stephen may want to make comment around the Atlantica and other kinds of agreements that are happening. But it's fair to say that BC was actually the one that kind of moved us down this path, and therefore we're taking particular interest. We will take interest in other interprovincial trade agreements because we are a national organization and have some comment in that regard. But
may I crystallize the intent of my question, sir? This agreement is bad in and of itself, period, or it's bad for BC?
I think it's a bad agreement. I would say that it's a bad agreement from the footing. The earlier question around whether or not you could actually put amendments to it, I believe, in my view, this is not a legal view, that the footing of this legislation is flawed and therefore cannot be repaired.
Do you agree with that, Mr. Shrybman?
Yes, I should have put it that straight, in those straightforward terms. Yeah, no, it's fundamentally flawed and can't be repaired. It's the wrong type of approach to, it's a shotgun to, unfortunately an unconstitutional one at that, to kill a fly.
And that applies just as much in Alberta as it does.
Absolutely, and actually we're doing an opinion on Bill 1, which is the statute which would implement TILMA in Alberta, which isn't moving as quickly in that province as it is here, and there's been more scope for debate in that province, but that'll be available in a week or two. Let me just add that no other province, though, has, though there's certainly discussions underway, I believe, between Ontario and Quebec. This has stopped at the Saskatchewan border. The government in Saskatchewan, the previous government in Saskatchewan, held hearings into the prospect of Saskatchewan joining the club created by Alberta and BC. And having heard from the people of the province, a great democratic exercise of public hearing, even the Saskatchewan party thought better of its commitment and turned away from it. So, one of the problems this regime suffers from is an absence of a commitment by either the governments of Alberta or British Columbia to have a candid conversation with people about why a measure like this is needed and what implications it will ultimately have. Alberta's gone down that road much further, and with the benefit of the understanding that's acquired in that regard, it stepped away. And we're convinced that's why you don't see other provinces jumping on this bandwagon either.
I guess the one point that I would make in my travels that British Columbians are asking, and I would ask myself, because that's the only answers I ever get, is if this is such a great piece of legislation, if it's so good for British Columbians, why hasn't it been debated in the House for months and months? Why isn't it in mainstream media? Why aren't we talking about it all the time? Some of my friends in the media have had as difficult a time getting information on the TILMA as we have. So it can't be that great if the government itself is not putting it out there for British Columbians to actually see, so that they can be proud of this. There's been no talk in the House. There's been no talk anywhere. I'm not sure because they don't have the answers to everything, but if it's that great, why aren't British Columbians absolutely thrilled to have it? If you go to most communities in British Columbia and talk about the TILMA, they wonder actually what you are talking about. Families that are going through some of the crises in this province aren't sitting around reading interprovincial trade agreements, nor are they reading the NAFTA or the AIT. So if it was that great, why aren't we telling people about it? That's the first kind of factor for me.
In your opinion, who stands to gain the most if this legislation is passed?
If I had to guess, it would be multinationals, very large corporations, and the biggest loser would be local governments. That would be my guess.
Do you have any thoughts around how this would reach into collective agreements or bargaining?
Well, I guess it depends on what the focus of the legislation really means. If it means that you need to actually drive qualifications to the lowest common denominator, to the floor, my guess is that nobody wants to make the kind of qualifications at the high end. It will have a significant impact on collective agreements because the law, I'm not a lawyer, but the law will supersede collective agreement in almost every case, I believe.
Some people have speculated that this is just greasing the skids for the Security and Prosperity Partnership. Do you have any thoughts on that?
Well, you know, I would think that there's a connection, but there's a connection everywhere, it seems, with trade, and certainly that's another whole new topic, and Stephen's been working a little, I'm not sure who's been working on it, but I know that Maud Barlow and the Council of Canadians, we've done a little bit of work on it, but it's just difficult enough just trying to figure out one at a time when you're overwhelmed with 9 or different bills. I think it's all running in the same direction. Certainly there are pieces that actually go together very well. But they're not the only two. The TILMA and the SPP are not the only two. And there are reasons for that I wouldn't want to speculate on right now, but the TILMA in particular, I think, is good for very, very large companies and not very good for local governments, whether it be municipalities or school boards.
Well, one of the ways in which the two are related is that, the Security and Prosperity Partnership is simply the next wave of NAFTA, of economic integration policies for North America, which really do constrain sovereignty and the regulatory authority of Canadian governments and our ability to control who gains access to our natural resources and whether there's any value added to them before they're exported to the U.S. markets. And NAFTA went an awfully long way in terms of removing the capacity of Canadian governments to safeguard the public interest in those ways. SPP has even a greater appetite for diminishing public control in Canada of everything from the way in which daycare services are delivered to whether raw logs are exported from the province, and those are, as you may know, now subject to a Chapter 11 challenge. The way in which TILMA connects with all of this is that under NAFTA and under the WTO rules, Canada, the federal government, has an obligation to ensure compliance by the provinces with the rules it's negotiated with other countries. But it has a problem because under our constitutional arrangement, matters of property and civil rights and environmental law and healthcare services are matters of provincial jurisdiction. The provinces aren't bound as a matter of constitutional law to comply with NAFTA requirements or with WTO requirements. And yet the federal government is liable for provincial noncompliance. So it needs a way in order to ensure that provinces comply with the international commitments it's made. TILMA is an excellent, so is the Agreement on Internal Trade, an excellent way to do that because it simply translates, in a very broad and very crude way, but an effective way, the basic essential features of free trade, which is an agenda for deregulation and privatization because it deals with services and investment, not just the trade in goods. So if you look at what a federal government would do in order to live up to its obligations under these agreements to ensure that municipalities, for example, comply with these arcane rules that it's negotiated with other countries, TILMA's the way to do that. So that's the relationship. And the SPP is simply the next wave of the same neoliberal agenda that's embedded in the WTO and NAFTA. Again, murky and obscure. We know it has something to do with water, something to do with energy. There's still an appetite for yet further diminishing the role of the Canadian state, whether that's in the form of a municipality or parliament or a provincial legislature or even a school board.